Welcome back to the deep dive. We're absolutely thrilled to have you here with us today because we are diving into a topic that is as legally complex as it is humanly tragic. We are looking at California's wrongful death and survivor statutes.
It is a heavy topic for sure.
Yeah, and specifically, we're exploring a highly technical area of civil procedure known as the statute of limitations relation back doctrine. And if you are out there wondering what relation back means, it is basically the legal equivalent of asking if a late homework assignment can, magically piggyback onto an assignment you actually turned in on time.
That is a remarkably accurate way to put it, actually.
Thanks. Our source for this exploration is a fascinating set of excerpts from a California Court of Appeal case, Quiroz v. 7th Avenue Center. The mission for our time together is clear. We're going to perform a rigorous, exhaustive, and detailed Socratic dissection of the court's reasoning in this case. We're going to break it down element by element to give you a true masterclass in legal analysis.
That is exactly the goal today. And to give you a roadmap of how we're going to navigate this analytical path, we will first examine two foundational legal doctrines that govern what happens when a person's life is cut short by the negligence of another. Those are wrongful death claim and survivor claims.
Right.
Once we have a firm grasp on the boundaries of those two distinct concepts, we will apply them directly to the Quiroz case to answer one incredibly important procedural question: can a late-filed survivor claim legally relate back to a timely filed wrongful death claim? It sounds highly technical, but as you will see, the entire case hinges on understanding the fundamental philosophical differences between these two types of claims.
Okay, let's unpack this. I want to start with the first major doctrine, wrongful death.
Mm-hmm.
When you hear that phrase in passing, it just sounds like a generic catch-all term for any lawsuit involving a fatality. But legally speaking, it is highly specific. Can you explain the statutory nature of a wrongful death claim and why it even exists?
I certainly can, and you've hit on something very important there. It is crucial to understand that wrongful death is entirely a creature of legislative grace. Think about how wild the old common law rules were.
How bad were they?
Well, under the old rules, personal tort claims simply expired when either the victim or the tortfeasor died. If someone injured you, you could sue them. But if they accidentally killed you, the legal claim literally died with you.
Wow.
Yeah, it was perversely cheaper for a negligent party if their victim died rather than just being severely injured. The legislature had to step in to fix that glaring loophole, so they created the wrongful death statutes. This law tells us that a cause of action for wrongful death does not affect the survival of the decedent's own legal claim. Instead, it's a totally new right of action based on entirely different principles. This new cause of action belongs not to the person who died, but rather it's a brand new right that vests solely in the decedent's heirs.
So if I'm tracking with you, this isn't the deceased person suing from beyond the grave to get justice for themselves. It is strictly for the surviving family members suing for this specific loss they just suffered.
Precisely. And because it's a strict statutory creation, courts interpret it very narrowly. There are exactly 3 testable elements that a plaintiff must prove to succeed in a wrongful death action.
Okay, what are they?
First, there must be a tort, meaning negligence or some other wrongful act committed by the defendant. Second, there must be a resulting death caused directly by that tort. And third, there must be damages, which the law strictly defines as consisting of the pecuniary loss suffered by the heirs.
Let's zoom in on that third element, because that word pecuniary is doing a massive amount of heavy lifting here. What exactly constitutes a pecuniary loss under this statute, and where do courts draw the line?
Pecuniary generally relates to money or quantifiable financial value, and the boundaries here are exact and rigid. Under the statute, an heir's pecuniary loss includes the loss of the decedent's financial support, their services, their training, and their advice.
Makes sense.
Right, and over the years, the courts have expanded this slightly to include the pecuniary value of the decedent's society and companionship. However, and this is a massive limitation that trips people up, it strictly excludes damages for grief, sorrow, sad emotions, or the sentimental value of the loss of a loved one.
I have to admit, reading this part of the statute felt incredibly cold. If someone is emotionally shattered, completely devastated by the sudden death of their spouse or parent, the law just says, sorry, we only do math here, and forbids them from recovering damages for that grief.
That is exactly what the law says, as harsh as it sounds. The policy behind this is actually rooted in judicial practicality. The goal of the statute is to provide compensation for measurable, quantifiable losses that the heir personally suffered due to the absence of the deceased.
So it's about keeping juries grounded.
Exactly. If juries were allowed to award damages based on the immeasurable depths of human sorrow, verdicts would be entirely subjective, potentially limitless, and driven purely by sympathy rather than evidence. By limiting it to pecuniary loss, even the pecuniary value of companionship, the law forces the jury to attach a somewhat objective, measurable value to the loss. It's a stark line, but it's a very clear, necessary legal boundary.
That is a fascinating way to look at it.
Yeah.
So if that is a wrongful death claim, a brand new lawsuit for the heir's own financial and companionship losses, how does a survivor claim differ from that?
The difference is night and day. Under the California survivor statutes, a survivor claim is not a new cause of action at all. It is the decedent's own pre-existing claim that survives their death and passes to their successor in interest or their personal representative.
Okay, so how does that work in practice?
Think of it like a relay race. If I am injured by someone's negligence and I file a lawsuit, but then I die before the trial from entirely unrelated causes, my lawsuit doesn't just disappear, it survives me. My estate picks up the baton I dropped and steps exactly into my shoes to continue the exact same lawsuit I started.
That makes perfect sense. The estate is just carrying the baton forward.
Yeah.
But what about the damages for a survivor claim? Are they limited in the same rigid way wrongful death damages are?
They are limited, yes, but in a completely different way based on a different underlying philosophy. The rule states that damages in a survivor action are strictly limited to the loss or damage that the decedent sustained or incurred before death.
So out-of-pocket stuff.
Exactly. This can include medical bills, lost wages while they were in the hospital, and even penalties or punitive damages that the decedent would have been entitled to recover had they lived. But importantly, the statute strictly excludes damages for the decedent's pain, suffering, or disfigurement.
Wait, hold on. So the estate can recover the medical bills the decedents racked up before dying, but they can't get a single dime for the actual physical agony the decedent experienced while lying in the hospital bed.
As a general rule, yes. And the policy rationale here is that pain and suffering damages are meant to comfort the victim. If the victim is dead, money can no longer comfort them, so awarding those damages would merely be a windfall to the heirs.
I see.
However, the law recognizes that in certain horrific, specific situations, this blanket prohibition creates an unjust result. So there is a very specific statutory exception to this rule against recovering for pre-death pain and suffering.
And what is that exception?
It's found in the Elder Abuse Act. Under this exception, if the neglect or abuse of an elder or a dependent adult is reckless, or if it is done with oppression, fraud, or malice, the successor in interest actually can recover damages for the decedent's pre-death pain and suffering.
Oh, wow. So it's a very specific carve-out.
Yes. The legislature created this specifically to severely punish and deter the abuse of society's most vulnerable members. But it's vital to note that even when this exception applies, it still does not expand the distinct damages available to the heir in their separate wrongful death claim. It only allows the estate to recover for the decedent's pain in the survivor claim.
Let's analyze Quiroz v. 7th Avenue Center. First, what are the legally dispositive facts?
So in 2001, Gilbert Quiroz, a dependent adult at a skilled nursing facility, suffered an untimely death. The appellant, Maria, filed a timely wrongful death lawsuit seeking compensation for her own injuries. Later, after the statute of limitations had expired, she attempted to add a survivor cause of action to seek damages for Gilbert's pre-death injuries, arguing this late claim should relate back to the original filing date.
And what was the core legal issue?
The issue is whether an untimely pleaded survivor cause of action seeking damages for the decedent's pre-death injuries relates back to a timely filed cause of action for wrongful death, which seeks compensation for the heir's own injuries.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
For a newly pleaded claim to relate back to an original timely complaint, it must seek recovery for the exact same injury. Therefore, the rule here has two comparative elements. First, the nature of the injury claimed in the wrongful death action, and second, the nature of the injury claimed in the survivor action.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the wrongful death injury?
The subrule is that wrongful death compensates the heir for their own personal pecuniary loss. Applying the facts, Maria's original timely claim was solely for her own loss of Gilbert's society and companionship resulting from his death. The court looked at this and concluded that this element represents a brand new injury unique to the heir. It is an injury suffered by Maria, not by Gilbert.
Understood. Now, what about the second element, the survivor claim injury?
The subrule is that a survivor action compensates for the decedent's pre-death injuries. Applying the facts, the late filed survivor claim sought compensation for the pain and suffering Gilbert endured before he died, which triggers that elder abuse exception we discussed earlier. However, the court concluded that this element represents a separate, distinct injury that originally belonged to Gilbert, not Maria.
And after analyzing all the elements, what was the court's final conclusion?
Because the survivor cause of action pleaded a completely different injury than the wrongful death cause of action, one belonging to the decedent, the other belonging to the heir, the court held that the survivor claim could not relate back to the date of the timely filed wrongful death claim. Therefore, the survivor claim was barred by the statute of limitations, and the court affirmed the judgment against Maria.
Here's where it gets really interesting. To cement this rigid boundary between these two legal concepts for you, the listener, I want to present a visceral, unforgettable hypothetical scenario.
I am ready for it.
Imagine a wealthy, elderly, eccentric uncle eating at a famously negligent restaurant. He is served a bowl of soup containing a razor-sharp rusted gear. He severely lacerates his mouth, suffers agony, and incurs massive medical bills for a full week in the hospital, and then tragically dies from the resulting infection.
That is a perfectly gruesome hypothetical to test exactly how these rules operate in practice. Let's dissect it. We have a single tortious act by the defendant serving the rusted gear in the soup. But we have two entirely different legal avenues that branch off from that one single act.
Right.
First, let's look at the agonizing week of mouth pain and the staggering medical bills the uncle incurred before his death. That constitutes the survivor claim. It belonged to the uncle the exact moment his mouth was cut, and upon his death, it passes to his estate. If the estate sues the restaurant, they are stepping into the uncle's shoes to recover the financial hit of those medical bills.
But not the pain, usually.
Exactly. Remember the general rule we discussed, unless this fits an exception like the Elder Abuse Act, which a standard restaurant negligence case absolutely does not, the estate cannot recover for that agonizing week of pain. They only get the economic damages, the medical bills, incurred before death.
Okay, what about the second avenue?
Now let's look at the niece. Let's assume she was an heir dependent on him. The niece's loss of her uncle's financial support and the pecuniary value of his companionship after he dies. That is the wrongful death claim. That claim did not exist while the uncle was lying in the hospital bed. It was born the exact second he died. It belongs entirely to the niece.
That makes the distinction incredibly sharp.
It does. So even though a single rusted gear caused absolutely everything in this tragic chain of events, the law sees two distinct victims and two entirely separate timelines of injury. And just like in the Quiroz case, if the niece sues on time for her wrongful death loss, but the estate waits too long to sue for the hospital bills, the estate's claim will be barred. It cannot relate back to the niece's claim because the law views her loss of companionship and his hospital bills as fundamentally different injuries suffered by different legal entities.
So what does this all mean for the listener when they sit down for an exam? How do you practically synthesize all of these distinct moving parts into a framework when you're staring down a complicated, convoluted fact pattern?
That is the most important question of this entire deep dive. To synthesize this module into an actionable, step-by-step diagnostic checklist, you should follow these 5 steps whenever you encounter a fatality in a torts or civil procedure question.
Step 1.
Number 1, identify the plaintiff. Ask yourself, who is actually suing? Is it an heir suing on their own behalf for the loss of their loved one? If so, you are in wrongful death territory. Or is it a personal representative or a successor suing on behalf of the decedent's estate? If it's the estate suing, you are dealing with a survivor claim. Getting this first step wrong will derail your entire analysis.
That sets the whole stage. What's number 2?
Number 2, identify the timing of the injury. Look closely at the timeline and the facts. Did the harm happen before the death, like medical bills, property damage, or lost wages while the victim was in the hospital? That is a survivor claim. Or is the harm directly caused by the death itself, like the sudden loss of a breadwinner's income going forward? That is a wrongful death claim.
Got it. And 3.
Number 3, classify the damages. Are the plaintiffs seeking compensation for the loss of companionship, society, and future financial support? That points entirely to wrongful death. Or are they seeking to recover medical bills incurred by the decedent or perhaps punitive damages that the decedent would have been entitled to? That points directly to a survivor claim.
Okay, 4 has to be about that tricky exception.
You know it. Number 4, check for the pain and suffering exception. If you have identified that you are dealing with a survivor claim, you must immediately flag any claim for pain and suffering damages as barred by default. That is a classic exam trap. But do not stop there. You must explicitly scan the fact pattern for hints that the Elder Abuse Act exception might apply.
So looking for specific keywords.
Exactly. Look for keywords indicating that the victim was an elder or dependent adult, and look for conduct by the defendant that rises to the level of recklessness, malice, fraud, or oppression. If those triggers are present, and only if they are present, the estate can recover for pre-death pain and suffering.
And the final step.
Number 5, statute of limitations and relation back. Remember the trap we saw in Quiroz. Never assume that a plaintiff can easily amend a complaint to add one of these claims to the other just because they arise from the same underlying accident or the same rusted gear. Because wrongful death and survivor claims involve fundamentally different injuries suffered by different legal entities, an untimely claim will not relate back to save it. If the statute of limitations has run on one, it is gone forever, regardless of the status of the other.
That checklist is an absolutely brilliant tool. It takes a labyrinth of civil procedure, statutory exceptions, and rigid common law histories and distills it into something highly manageable for an exam setting. We have covered a tremendous amount of ground today, from the rigid origins of these rules to the deeply technical application of the relation-back doctrine in the Quiroz case. Thank you for following along on this rigorous legal journey with us. You have tackled some genuinely challenging concepts today, and you are far better equipped to analyze these issues going forward.
It's been a great discussion.
Before we wrap up, I want to leave you with a final provocative thought to mull over on your own. Consider the strict damage rules we just analyzed. If a wrongful death claim forbids recovery for an heir's grief or sorrow, and a standard survivor claim forbids recovery for a decedent's pre-death pain and suffering, it creates a massive emotional gap in the law. Under normal circumstances, who, if anyone, is the legal system actually compensating for the sheer human agony of losing a loved one?